Good morning, Facebook. Happy Friday. Hope everybody's doing well today. My name is Lindsay Wagner. I'm one of the attorneys at Scott Wagner and Associates PA with offices in Florida and California. We represent employees and employers across the United States. I manage our Los Angeles, California office, and today we are focusing on questions regarding workplace protections during the coronavirus pandemic for California employees. So, interestingly, today we're going to really cover specifics about California employees, but in the context of examining the new federal legislation as well. So, even if you're not in California, there can be some provisions that we'll be talking about today that can be helpful for individuals outside of California as well. But this presentation is primarily focused on California laws. So if you've been following some of our slides from before and our presentations, you may have seen some of our information about essential businesses. But as we're talking about employee protections during the coronavirus pandemic, examining what is an essential business is important. Why? Because most of California, cities have their own safer at home or stay at home orders, but overall, the state of California is on a stay at home order. This means that unless you're working for an essential business, you have to be able to work from home. And if you can't work from home, then we'll talk about what options you might have under the law that can give you protections for unemployment, disability, and so forth. But when we're talking about essential businesses that are able to stay open despite these stay-at-home acts, we're looking at what is an essential business by state and local regulations. So for the guidance for what is an essential business, the U.S. Department of Homeland Security issued guidance of 16 economic sectors that are essential business. So if you work in one of these companies or businesses that fall within these categories, you're going to be working in an essential business, and that employer is going to be permitted to stay open and require employees to come into work unless they have extenuating circumstances despite the fact that we have stay-at-home orders. Non-essential businesses can remain open as long as their employees can continue work from telecommuting and other means, and we'll talk about that. So what are these essential businesses that can stay open? These are going to include your healthcare operations, your hospitals, elder cares, home healthcare workers, medical supply providers, doctors and dentists' office, and veterinary and animal health services. They're also going to include infrastructure companies, so power generation, fuel supply, gas stations, airports, transportation, manufacturing, so especially companies that are manufacturing goods and supplies, paper products, medical equipment, as we've seen in the news that's so necessary, and telecommunications. For retail businesses, grocery stores are going to be able to remain open, and restaurants and bars, even under the California stay-at-home, as long as they're offering takeout or curbside pickup. Certified farmers markets can also stay open, and certain convenience stores. We're also going to see services that are covered under the essential businesses, your trash, recycling, laundromat, your FedEx mail shipping services, auto repair, and animal shelters. Other businesses that are included as an essential business under these guidelines that have actually been adopted by California's stay-at-home order are going to be your news media, which is very broad, your financial institutions, banks, insurance, payroll, accounting, providers of basic necessities like your homeless shelters, food banks. For the construction industry, it's really going to be specific to construction that's offering emergency repair, safety construction. If you're working in an industry that's construction, it would be helpful to get guidance as to whether or not that construction company is an essential business. Defense is one that's also going to be covered. So, any defense companies that might be supporting the U.S. government, contractors, federal contractors. And then, lastly, a general catch all, your services to maintain the safety, sanitation, and essential operations of residences. So, your fire prevention, waste management, law enforcement, and auto repair. One of the things that's important about the essential businesses is that while they can remain open, obviously an essential business can choose to close. Also, we might see that certain essential businesses have opted to modify their hours, like certain banks or restaurants, maybe offering only evening service or other kinds of modifications of their hours. So that's important. Another thing that's important for California employees to know is just because your company claims to be an essential business doesn't mean that it is. So we'll talk about what to do with the common question of what can I do if my employer thinks that I'm an essential business, but I don't believe I am. Are there ways to challenge that? So we can talk about that as well during the presentation. Coming to the next slide. So certain states, like New York, allow for a relief waiver from shutdown, and states like Washington provide a website for re-entry registration for clarification or certification of the status, or to petition to be added to the list. So this is specific for employers, that there are ways for them to seek inclusion on those lists. Like if your employer does something that isn't squarely fit within the categories, but they think it should be, they might be able to apply. So if you're wondering, well, my business isn't squarely fit within there, it could be that your company was able to get a waiver from the shutdown orders. If you don't think that's the case, then we'll talk about what that means as well. But there can also be non-essential positions within an essential business. And so we've been getting further guidance about this. So what if you're in a position where you can telecommute and work from home, such as maybe you work from a hospital, but you're in an accounting department and you can actually telecommute. It really leaves it up to the employers to make a decision about that. And as time goes by, we're seeing more guidance come out on that. So I would stay tuned to see what else we're going to find out about these non-essential positions within an essential business. At this time, we're really seeing that if you work within a hospital, for instance, and your company, your hospital is saying, hey, we're an essential business, you need to come in, even if you're doing accounting, that's going to be permissible within the stay-at-home orders. But there's guidance coming out on a near daily basis on that, so it's really a moving target. I would say the best bit of advice for employees, if you have questions about whether or not you're working in an essential business or whether or not you're an essential position within an essential business, is to seek advice from a qualified employment lawyer. There can be certain protections for individuals who make complaints or inquiries about whether or not they're in an essential business and then get retaliated against for that, but it's always advisable, if you have those sorts of questions, to seek guidance from an employment lawyer first. So then the question is, what if my business is clearly not an essential business, but they're staying in business despite the violations of the orders? So different stay-at-home orders within cities and counties have penalties based on the orders. So citations, fines, license, suspension. There can even be criminal penalties. Interestingly, I've seen that Mayor Garcetti has actually entertained the idea in Los Angeles that he would authorize shutting down certain utilities to businesses that stay open despite those orders. So they are trying to enforce these and taking it seriously. So there can be repercussions for businesses that stay in business in violation of the orders. States like California have laws that incentivize employers to comply. Like there can be certain lawsuit claims that you could have against your employer if they decide to stay open in violation of the stay-at-home orders, like maybe a potential unfair competition claim. If you raise a complaint and say, hey, employer, you're not an essential business and I have concerns about my health and safety and violations of this order, and your boss fires you, you might have a retaliation or wrongful termination claim. Again, it would be advisable to speak with the labor and employment lawyer about those questions, but there can be recourses for employees who have concerns about their employer staying in business in violation of these orders. So now we get to the fun part here. And this is, what if you're losing wages because of the coronavirus? So we're going to go through, if you're losing wages, if you're still working but losing wages, what are your different options? And this presentation focuses on both federal regulations and also California specific opportunities. So California has 2 state-run programs for wage replacement. And when we say wage replacement, these are really for individuals who maybe have a reduction of hours. So maybe you're still working, but your hours have been cut substantially. You might be able to get some state relief for the reduction of hours and the loss of pay that you might be getting. And then also individuals who are completely laid off, furloughed, or otherwise out of a job. So those are run through the Employment Development Department, or otherwise known as EDD. For those of you not familiar with this, EDD has some great reference material on their website. You can apply for your benefits through the EDD process. I know some people have expressed frustration about being able to get through for filing for their benefits. Be patient, try to apply during off hours, later at night, early in the morning. The system has been overrun with applications so far. So I know that they're trying to make improvements to that, but it has gotten quite a lot of applications, as you can imagine. So the 2 different wage replacements that are available for California individuals that are losing money because of COVID-19, either because of a loss of a job or reduction of hours, are unemployment insurance and state disability insurance. Traditionally, under California, you had to have a 1-week waiting period for unemployed or disabled. So you had to have lost your job a week before, and then you could apply for the unemployment. But Governor Newsom has actually waived that 1-week waiting period due to COVID-19, so you can go ahead and apply as soon as those hours are reduced or as soon as you lose your job. So what is unemployment insurance? In California, unemployment insurance is provided for workers who have lost their job, like we talked about, or whose hours are reduced. And this covers about 50% of your wages, up to $450 per week. It's important to note that this is taxable though too, so the $450 a week would be less taxes. But since we've had the COVID-19 pandemic, we've also had the enactment of the Federal CARES Act. And so this is also part of a stimulus bill, and this will add from the federal government $600 weekly to the check, to your unemployment check. So if you can get up to the $450 per week that's taxable, the Federal CARES Act will add an additional $600 onto that check, potentially, and it extends the maximum week of benefits that you traditionally could get from unemployment from 26 weeks all the way up to 39 weeks. The other cool part about the Federal CARES Act is it can allow for retroactive payment of benefits. So if beginning January 27th, 2020, you were laid off of your job for coronavirus or your hours were reduced, you can actually start getting that additional benefit from the Federal CARES Act up until that date. The other thing that we've commonly heard from the stimulus bill to point out is that if you haven't already, there's checks that have been sent out for certain individuals for that $1,200 stimulus check that individuals will get to, plus an additional $500 per child. This is federal regulation, so it applies to everybody across the United States. But it's important to know that those credits phase out for that stimulus for individuals earning $75,000 to $99,000 a year. So if you are an individual who earned over $99,000 in a year, unfortunately, you're not going to get a stimulus check. But between the 75 and 99, the credit amount goes goes down. It also can go down based on a couple income that has $150,000 to $198,000. The other cool part about the new CARES Act is that it actually opens up unemployment benefits to individuals who might have not traditionally been eligible for that, like self-employed and independent contractors. So for all of you out there who are self-employed or independent contractors, you too can now get unemployment insurance by the CARES Act. And also, there can be other reasons, not just that you lost your job or that your hours are reduced, but if you have to miss work for childcare after your school has closed, we'll talk about that in the Family First Response Act. You might actually get partial pay if your hours are reduced. So, all of these fun things about unemployment insurance through California. So then we go to what's state disability insurance. So this is a little bit different than the unemployment. So this is for anyone who has a disability that's an illness or injury preventing the regular or customary work. So in order to qualify, the worker has to be unable to work for at least 8 days and submit an application within 49 days of the first day that they had to stop working for a disability. So keep in mind, if you're unable to work, there's a time limit as to when you're going to be able to apply for state disability insurance. You have to do it within the 49 days of the first day that you had to stop working because of a disability. There's certification requirements that you have to submit documents from your healthcare practitioner. But the interesting part here for COVID is that state disability insurance, you can be eligible for this if you can't work due to having or been exposed to COVID-19. If your medical professional says that that's the case, it has to be certified. The other really neat part about state disability insurance is you might qualify for receiving the state disability insurance if you can't work because you're in an age-defined vulnerable population. So if you're over 65 and because of that you're not able to work because of potential exposure to COVID, then that actually age-related condition could be an illness and you could potentially be qualified for state disability insurance. So that's really important for some older workers who might not be able to work now because of the pandemic. The other things that are important to know for state disability insurance is that it's tax exempt, unlike unemployment that is taxable, and it's only available for employees, unlike unemployment that can be available for independent contractors. I say that with a caveat. If you are an independent contractor who's been misclassified, of course, and you really should be an employee, you could also potentially be eligible for state disability insurance if you qualify for the other reasons. So this is just a little recap about your state disability insurance that you can get this for paid family leave as well. So also through EDD, if you're unable to work because you're caring for an ill or quarantined family member with COVID, you can actually, in California, this is specific to California, qualify for paid family leave benefits. Now, these are in addition to the benefits that we talked about before, and you can get up to 6 weeks of paid family leave at the state disability rate that we just talked about. So if you are employed and you're not able to work because you have to take care of an ill or quarantined family member with COVID, then you could be eligible for paid family leave benefits. You can apply for those through EDD the same way as you would for state disability insurance. So that's an important addition that Californians have and specific to California. So what about if your school closes, your child's school? You've got children, their school closes, now you can't work because you've lost out on the care that you had for them, or maybe you're in a situation where you have your child's care provider, babysitter, or whatever is now not able to come to your house because they're having to quarantine. That would also qualify under this circumstance. So we're talking today then about the Families First Coronavirus Response Act, which went into effect on Monday, April 1st. and that's a federal regulation. So the Families First Response Act says that employees who have worked for a certain employer for at least 30 days can get up to 12 weeks of leave, 12 weeks of paid leave at 2/3 their regular rate of pay, up to $200 per day if you have to miss work because you're caring for your child and their school closes. So if you're working and your business is still open, then you can potentially get covered under these pays. Now, it's important to know that the Families First Corona Response Act only applies to employers with less than 500 employees. So if you work for a big corporation, you're not going to be able to take advantage of these benefits, but if you work for an organization with less than 500 employees, you can be eligible. Since we've been preparing these slides, and as I told you, all these laws keep changing on a daily basis, the Department of Labor has issued just the other day some new regulations clarifying even further about this 12 weeks of leave if your child's school closes. So it's important to know that small businesses, for employers that have 49 or fewer employees, can actually decline that 12 weeks of paid leave for employees if it would cause that small business to stop operating, or if there would be a substantial risk to the employer because they can't cover the shift for the individual, so they can't find somebody to fill in for you for your job. So for smaller employers, they can actually go ahead and decline your right to be able to take the leave if they're smaller, and it's going to pose a hardship on them. So we've gotten that clarification from the Department of Labor. It's also important to know that there are certain exemptions to employees who qualify for this, such as healthcare providers and first responders. The Department of Labor actually clarified that this can extend even to employees at entities that contract with healthcare providers and first responders. They might actually also be exempt from providing this sort of leave. So that's important to know. If you don't have the ability to take this leave, there is coverage under the California Labor Code. So employers with more than 25 employees, that's counted by individuals working at the same location, have to give employees up to 40 hours of leave per year for an emergency at the child's school. So if the school closes, you can't take advantage of the Families First Response Act, you still might be covered under the California Labor Code. And that's helpful because that's going to be especially beneficial for individuals working with employers of more than 500 employees. They still might have some coverage for some leave under the California Labor Code, even if they're not covered under the Family First Response Act. So then the next question is, well, what if you're losing your health insurance because you've been furloughed or laid off? This can be especially scary with the virus going around at this point. So pay attention to this. If you're worried about losing your health insurance, what can you do? First, there's federal and California COBRA. So this requires employers with at least 2 employees to offer continuation of the employer-sponsored health plan up to 36 months at the same monthly rate the employer paid for the premium. So the important thing to know is that's not what you were paying for the premium while you were working, but what your employer was paying. So it's usually more than what you were paying for your health insurance, but you still get to cover and carry on with the same plan that you had if you elect to do your Florida or your federal and California COBRA. Alternatively, there's also options through Covered California. Traditionally, you'd have to wait for an enrollment period to open, but due to COVID-19, for individuals who don't have health insurance, regardless if you were furloughed, laid off, maybe you just didn't get it and now you're thinking it's a good time to get it, they've opened up in California a special enrollment period for all Californians until June 30th, 2020. So if you don't have health insurance, either because you've been furloughed or laid off, maybe you don't qualify for California COBRA or it's too expensive, you can do the special enrollment through Covered California. That's an open enrollment period up and until June 30th. So what if you get sick or you need to care for your family? These are for individuals who are still employed and now you've become sick or you have to care for a sick family member. What are your options? So we're going to revisit again the Families First Coronavirus Response Act. It's a mouthful, but it provides emergency paid sick and family leave. And so what does this cover? Like we talked about, it's employers up to 500 employees. So if you have questions about whether or not your employer is covered, you can seek guidance through the Department of Labor or talk to an employment attorney who can help guide you. There's new regulations that just came out from the Department of Labor that tell us how to calculate the number of employees, what might be reasons that you would be able to take the emergency paid sick leave, and further explaining what was already passed in the act that went into effect on April 1st. So it's important to know for the sick leave that employers can't require that your regular sick leave or your PTO be used before the use of this leave. So let's say, for instance, you're a worker, you have 9 days of PTO available. Your employer can't say, well, first you have to use your 9 days of PTO and then you can take the Family First sick leave. They have to actually give you the Family First sick leave first and then allow you, if you need it, the 9 days of PTO. So what do you get under this new law? If you need sick leave, you're going to get up to 10 days or 80 hours of sick leave. And we'll talk about what does that mean, who qualifies for that. But you can get up to 10 days paid sick leave if you're a full-time employee. The Department of Labor clarified that if you're a part-time employee, you're going to get less, obviously, than the 80 hours of paid leave. We're going to calculate that by looking at your normal weekly schedule and then pay you what you're going to get in that normal 2-week period. If your schedule varies, there's other ways to calculate what your sick leave is. And then also there's another type of leave. So it's the 12 weeks of paid emergency leave. What does that mean and who gets that? We'll talk about that, but it's important to know the first 10 days of this paid emergency leave are unpaid. Likely you're going to be able to take advantage, though, of the 10 days of paid emergency sick leave. And then after that 10 days have expired, if you qualify for the 12 weeks of paid emergency leave, you're going to get 2/3 your your regular rate of pay for the emergency leave. So what does this all mean? If I'm sick or I care for my family, when do I get to take advantage of these different provisions here? So the 10 days of sick leave, who gets that? Employees employed for any length of time, so you don't have to have a minimum employment requirement. You have to be unable to work or telework, which is important, due to COVID-19. So if your employer stays open, that's the important part, if they're still open and you can't work or telecommute because you're subject to a quarantine, because you've been advised by a healthcare provider to self-quarantine, because you yourself have symptoms of COVID-19, because you're caring for someone else subject to a quarantine order, or because you're caring for a child if your school closed, then you might be entitled to take that 10 days of sick leave. But it's important here because in California, everybody's subject to a state quarantine order. So does that mean that everybody can take the 10 days of sick leave? No. So the answer to that is, and we got some clarification from the Department of Labor, if you're able to telework, even if you're under a state quarantine, you can still work. You're not going to be entitled to the sick leave. So for instance, as a lawyer, our business is open. I can telework. So I'm not going to get that 10 days of sick leave because even though I'm subject to a stay-at-home order. Now, let's look at another example. What if my power goes out and I'm subject to a local quarantine order? I can't go down to a coffee shop or a work-sharing location and work because I have to stay at home. Then that's an extenuating circumstance and I might be qualified for the 10 days of sick leave. If your employer isn't offering telecommute options for you, but they're staying open, you can also qualify for those 10 days of sick leave. But let's talk about another example. What if you're working at a coffee shop, for instance, you're a cashier, your coffee shop closed because of COVID, and you're still under a stay-at-home order because you're living in California, you can't work anyway because your company's closed, so you're not going to qualify for the sick leave. In that situation, you'd be better off exploring unemployment benefits because your company's not staying open. So that's a little bit about the 10 days of sick leave. But what about this 12 weeks of emergency paid leave? 12 weeks is a lot more time of paid leave than 10 days. So who qualifies for that? It's very limited circumstances. It's only for employees who are unable to work or telework, again important, because they have to care for a child under the 18 if their school is closed due to childcare being unavailable. So those employees have to have worked for the employer for at least 30 calendar days. So as long as you qualify for that, you can potentially qualify for those 12 weeks of paid leave. But remember, like we talked about before, there can be certain exemptions depending on if you're a healthcare worker or if you're working for a company with 49 or fewer employees. That employer might be able to decline the 12 weeks paid leave to you. So that's a little bit about the Families First Coronavirus Response Act. But it's also important, if you can't take advantage of either of these, or even in addition to this, you can also take your accrued paid sick days. In California, for instance, there's certain cities that actually require employers provide a minimum amount of sick leave for individuals. For instance, Los Angeles and Santa Monica have local ordinances where individuals can get 6 or even 9 days per year of sick leave. So that's another opportunity that you might have to take that sick time if you don't qualify for the Families First, or if you only qualify for the 10 days and then you need extra time and you don't qualify for the 12 weeks. So theoretically, if you're in LA or Santa Monica, you use your 10 days of sick leave and you need more, you might be able to use your 6 to 9 days of leave. So that's important to consider. What if you're vulnerable to COVID-19? So this has been a really common question for employees. So I have a serious medical condition. I'm concerned that I'm going to get sick. My employer is requiring me to go into the office. What can I do? We're an essential business. I have to stay open and go in. Do I have recourse? Good question. So under California, we have the benefit of the California Fair Employment and Housing Act, which we might otherwise be known as FEHA. Now, this requires employers with at least 5 employees to consider reasonable accommodations for a disability, and that could include work from home or medical leaves for certain individuals with a disability. So if you're working in an essential business and your employer says you need to come into the office to work, but you have a disability and that's going to put you at high risk for COVID, you might be able to take advantage of your rights under FEHA to be able to request a reasonable accommodation for your disability and ask to telecommute or work from home. The employer then has to engage in what's called a good faith interactive process to see if they can accommodate you for that. So if you make the request and your employer says, no way, Jose, we can't consider that, and doesn't give it a second thought, that's not going to qualify under the good faith interactive process. The employer has to work with you to see, are there ways that they could set up for you to be able to work telecommute? If the employer says, sorry, we just don't do that as a practice, that's not going to be a good enough answer either. They really do have to work with the individual on a case-by-case basis to determine if they can meet their accommodation. If you have questions about this, it's very important that you do seek guidance from an employment lawyer. Many employment lawyers like us offer free consultations for these kind of things. And so if you have a question, if you're having issues because you're vulnerable to COVID and your employer is still requiring you to come into the office, the Department of Fair Employment and Housing has great guidance on its website, but you could also seek guidance from an employment attorney who might be able to help you with those answers. So if your concern is about exposure in the workplace and maybe that your employer isn't providing safety protocols. Maybe they're not abiding by the 6-foot rule. Maybe you're in a high risk situation and you're not getting proper safety gear. There is guidance through Cal OSHA online for industry guidelines for healthcare providers and childcare providers for certain services. So if you think that your employer should be following those and they're not, you might be able to make a complaint to your employer about that, specifically listing the facts of your situation and why you don't believe that your employer is creating a safe working environment. And if you're retaliated against for that, you might have a potential whistleblower or wrongful termination case. So that's specific to California and important to know. Again, if you have questions about it, it's always advisable to talk to an employment lawyer even before you make the complaint, just to make sure that you're following the right procedures to protect yourself if you are terminated. So that's all of our presentation for today. There's a lot of information to cover, and I tried to cover as much as I could as briefly as possible. But as always, if you have any questions, we remain here and available to assist you. We have offices in Florida and California and assist employees across the United States. If you want to set up a consultation, you can give us a call or you can visit our website. Best of luck to everybody out there. Stay safe and happy Friday. Thanks